A patent is a form of a contract. It's what we call a quid pro quo, one for one, in that the government says, look, and this was kind of the idea behind the patent system, is that if you disclose your invention, you describe in full and complete terms how to make and use your invention, the government gives you, in return, a right to have exclusive use of that technology. It also is based in the Constitution to promote the progress of science and the useful arts for limited times, to inventors, and giving them the exclusive right to their discoveries. Note that a patent doesn't give you the right to actually do anything except to stop others from doing something. In other words, you can have a patent on an invention that can be dominated by some other patent. So, there might be a patent on this display device, but you came up with an improvement of how this, this projector head is adjustable. So you can get a patent on that invention, but guess what? You can't use it because the owner of the overall device patent has the exclusive rights to use that. So it's perhaps a subtlety, but it's very important. Again, getting a patent on something doesn't give you the right to make or use that invention necessarily. It gives you the right to stop others. Requirements for patents, there's these 4 sections, 101, 102, 103, and 112. 101 has been in the news more recently, a lot of Supreme Court activity over the last couple of years, including currently, that really defines what the scope of patent protection could be, what kinds of things are eligible for patent protection. The current debate and dispute and a case in front of the Supreme Court, they just had oral arguments a couple weeks ago, relates to the patentability of computer software. And we'll talk a little bit about that later on. Section 102, novelty, means it has to be new. It just has to be something that wasn't done pretty much exactly before in that form. And 103 expands that analysis and says, well, even if it wasn't done exactly the same way, is what you're trying to protect just an obvious variation of what others have done. So it has to be non-obvious for you to get a patent. And then section 112 says, if you're going to get patent protection, you need to fully describe and enable your invention.